This is case number 2010-0503, State of New Hampshire versus Anthony Balliro.
Mr. Berman?
Yes, good morning, Your Honors. Andrew Berman for the defendant, Anthony Balliro. I thank the court for granting my admission pro hac vice, and I thank Attorney Horan for sponsoring me in that regard. I'm pleased to take questions at any time. We're here, Your Honors, because we have an abiding belief that Mr. Balliro did not receive a fair trial associated with his conviction for first-degree murder and 2 counts of arson. Primarily, we hold this belief, Your Honors, due to the fact that on numerous occasions, multiple level hearsay was admitted against Mr. Balliro. That hearsay consisting of statements supposedly made by Mr. Balliro to the decedent, wherein Mr. Balliro allegedly threatened to kill the victim. The victim, to state the obvious, was not available for cross-examination at trial. The victim became Mr. Balliro's primary accuser.
What about our decision in Hall? Is Hall, could defense counsel have read Hall, whether it's right or wrong, and said, gee, I think this stuff is going to come in?
Absolutely not, Your Honor, and that I think is a crucial issue in the case. In the oral argument in the Hall case, one of the justices, it wasn't apparent from the audio recording, made a distinction. Does this case involve the underlying reasons and beliefs for the fear? And Hall clearly does not. It's apparent on the very first page of the decision, or the second page, wherein they relate precisely what the mother's statements were as it relates to the fear of her son.
So you say that Hall is limited to the state of mind in terms of fear and not the underlying factual allegations?
Precisely, and I think that's apparent in the face of 803.3, which says that it has to relate to the specific moment in which you're feeling that state of mind and not to any prior history which may have led to that state of mind.
So even if Hall is not controlling, the state argues defense counsel made a tactical decision to bring all this other stuff out to show that the victim here was not a very nice person.
I don't believe that was a reasonable tactical decision. The weight of the evidence presented against Mr. Balliro, not only with respect to the hearsay statements of Mr. Hayes relating to the threats supposedly made by Mr. Balliro, but the character evidence that was entered into evidence without objection relating to Mr. Balliro's alleged character for violence and instability and quote-unquote prone to going Western on people. The point is, and I'm sorry, I lost your Honor's question.
Tactics. Wasn't this just a tactic? Wasn't this just a tactical?
I don't believe it was reasonable because the weight of that evidence, I think, is extremely prejudicial. I think it destroyed Mr. Balliro's case from the outset. And number two, I believe that there would have been ways for defense counsel to get into evidence the threats made by Mr. Hayes, the victim, to Ms. DeFelice. I believe that those would have been clearly admissible as statements against penal interest. Not only that, but the statements made by Mr. Hayes relating to his threats against Mr. Balliro are not multiple level hearsay. What we've got being offered against Mr. Balliro are statements that are completely unreliable, completely prejudicial in the context of a first-degree murder case. We've got Mr. Hayes speaking from the grave that Mr. Balliro threatened him in a case where he's accused of killing him. And not only that, Your Honors, if I may, if that were a tactical decision, a reasonable tactical decision, and I respectfully disagree with that, there was no attempt, despite a prior concession during the course of a motion hearing that they would not be admitted for substantive purposes, to limit the significance of that testimony whatsoever. It was admitted for all substantive purposes. It wasn't just admitted to go to Mr. Hayes' state of mind as probative of whether he was the first aggressor. It was admitted for all purposes, and the government seized on that in their closing arguments, and I quote them directly in my brief. This is where Mr. Balliro's heart goes when he says these things. It's clearly being used for the purposes which 803.3 exists to prevent, and that is to show that because the threats were made, that Mr. Balliro, therefore, was more likely to have acted in conformity with those threats. He did not receive a fair trial in this matter, not only because of the hearsay statements and the character evidence which was offered into evidence, but also because of the impeachment with the prior act on the liquor license application, and these references to a hitman and Italian lightning, which clearly plays into a characterization of Mr. Balliro as somehow being associated with the mafia.
Thank you, Mr. Berman.
Thank you, Your Honor.